Hi there, Ms. Miller. Hope you're having a good day. I wanted to follow up with a video. People have described my uh, email and thought process as voluminous, so I thought maybe it'd be easier just to parse through if I just have a normal discussion with you about the stuff that's on my mind. Um, Firstly, you stated that my constitutional arguments may make me look like a sovereign citizen. From what I know of sovereign citizens, they claim that the Constitution and the laws have no sway over them because they are sovereign from the United States. My position is exactly polar opposite, that these laws of the land, that this social contract that we have between us, we the people and the government, is sacrosanct. That when there are inalienable rights, that's exactly what they mean, inalienable. I'm a great follower of John Locke, father of liberalism, grandfather of the U.S. Constitution. So I really take having my rights seriously. Um, I have autism, man. It's like being a manager and a business owner. My job's often to make sure things are moving forward. So when we're face to face, I make things move forward. So that's something I got to watch out for. I shouldn't even allowed you to take that offer to those other people. I'm up for what, criminal trespass? So that's like what, 1 day in jail, $300 fine. If anybody asked me if they could buy my rights for $300, you know, there's just no way, you know. Um, yeah, that's not that's not that's not something really, ma'am, that should ever be suggested to anyone, especially in my situation. Uh, Starting off at number one, inalienable rights to life, liberty, pursuit of happiness. Liberty is a method of how you live your life. For instance, I am a liberal, a protester. I get out and do activism. For the court to tell me that I have no right to interact with my state government or the Jefferson County is a violation of my liberty and the way I live my life. I live my life lawfully, and the activities I undertook are protected by the U.S. Constitution. If the state of Alabama doesn't think that I have these rights, it really doesn't matter to me because I have federal protections. If you feel like this is not the case, we can discuss that further at a later time. Uh, Item number two here. I'd like to subpoena my accuser, Deputy Lee, and the two civil servants that discriminated against either my religion or my sexuality. Uh, when I said the word Jew, the laughter stopped, and you tried to make an excuse for this woman. You can say that she's a southern white woman, but that's your opinion. I don't even know where you got this unless you've spoken to her. And that was her explanation as to why she decided that I, as a citizen, did not deserve to have rights and respect that day. Your job is to make excuses for your clients, not the people who victimize your clients. It's just a general statement. It goes for me, but also for others. If there's someone who's violating the law against your clients, you should see that as exactly that someone has violated your client's rights. It's not any relevance that she's a woman. There's no relevance that she's Southern. There's no relevance at all other than that citizens have a right to service and that civil servants don't have the right to choose who they do and do not give services to. Um, this woman had no right to, deny me services, and she came at me physically twice. She tried to create a physical confrontation with a citizen 2 times. You know, she made physical contact with me. If I had been within my rights and protected myself from further assault, what do you think would have happened? It's just not okay for civil servants to come from out behind the counter and start approaching citizens physically. That's just not the world we live in. That's not civilized. It's not lawful. I was lawfully recording in that building. I was providing remonstrances as is a constitutional right in Alabama. When she denied me services, you know, that's just not the end of the day. Civil servants don't get just to break the law and then you just have to deal with it and go away. You have a right to free speech. You have a right to protest. You have a right to remonstrance. The civil servants have no right to be unlawful just because they don't appreciate citizens utilizing their lawful rights. I mean, that's just the reality of it. Under the Bill of Rights, I have the First Amendment and the Sixth Amendment. We'll discuss those further. What's going on is called a deprivation of rights under the color of law. This is the United States Department of Justice web page right here. What it states here is that Section 242 of Title 18 makes it a crime for a person acting under color of any law to willfully deprive a person of a right or privilege protected by the Constitution or laws of the United States. When Deputy Lee came in there and used the color of law to deprive me of my First Amendment activities that I was currently engaged in, he deprived me of my rights under the color of law. That's just the reality of it. For the purposes of Section 242, acts under color of law include acts not only done by federal, state, or local officials within their lawful authority, but also acts done beyond the bounds of that official's lawful authority. If the acts are done while the official is purporting or pretending to act in the performance of his or her official duties. Persons acting under the color of law within the meaning of this statute include police officers, prison guards, and other law enforcement officials, as well as judges, care providers, and public health facilities, and others who are acting as public officials, like those civil servants at the window. It is not necessary that the crime be motivated by animus toward the race, color, religion, sex, handicap, familial status, or national origin of the victim. It really, really seems like the federal government is sitting here saying that Deputy Lee and those civil servants just simply had no right to deprive me of my rights under the color of law. Moving on, you can see that says judges and prosecutors and care providers. When the prosecution, let me return to my list. I don't want to jump around too much. I want to stay kind of formatted here. In America, we have a presumption of innocence, and the removal of my constitutional rights as an innocent American concerns me. According to federal law, Section 242, it makes it a crime for the judge to have removed certain rights of mine, and I'll go through there. I have a constitutional right under the U.S. Constitution to free speech to petition. When the court told me that I had no right to contact the state of Alabama, and later the Jefferson County Police Office, that judge removed my right to free speech to petition. She removed my right to protest. She removed my rights, as well as what I was doing in the course of being unlawfully removed my rights to record my civil servants in the course of their duties. I have a right to enter public places, to be able to record those civil servants, which she preempted my rights. And I'll remind you again that this was done using a domestic violence law to get a protection order against a citizen to protect the entire state of Alabama, and later the entire armed force of Jefferson County Sheriff's Office, to protect them using a domestic violence law from exercising First Amendment rights. I have constitutional rights to petition the government. Petitioning the government means to access that complaint form. Under Alabama Constitution, I have a right to free speech as well. I misspoke there. What I was trying to refer to is the Open Records Act of Alabama. That gives all persons a right to copy and inspect documents written and controlled by the state. They removed that right from me as well. Under the Sixth Amendment, I have a right to a fair trial. Without me being able to access the scene of the crime under Discovery Rule 16.1, I can't have a fair trial. I'd love to subpoena those two civil servants that came out and physically assaulted me. I mean, the one woman and the other one that was specifically told me that she was discriminating against me, but because of the removal of my free speech rights and rights under Discovery 16.1, I can't even go into that building to find out the name of the people to gather witnesses as a part of my defense. By me not being able to have access to those documents that you got, so I know they exist, for some reason I was denied those documents under Rules of Discovery 16.1. And they being public documents held by my public civil servants, I should have had every right under the Constitution, both of America and Alabama, to go and access those documents to formulate a defense for myself. But I had that right preemptively removed from me under the color of law. I have a right to know the charges against me, according to the Sixth Amendment. According to the Rules of Criminal Procedure, once I presented them in writing a request to know the charges against me, I had 14 days to respond, and they simply refused to do that. And I again remind you that they refused to allow me to have an arraignment or a pretrial. The judge said that she would not hear motions until pretrial, and then just skip the pretrial. Every point of this trial where I have been allowed to speak for myself, raise objections, put in motions, I've been denied the right to even be present in my own trial. And I know you sit there and say in Rule 4.4, but this is not about me getting out of jail, and it's not about initial appearance. This is about Rule 9 that specifically, word for word, says arraignment and pretrial. Not quite sure where the disconnect in that one is when the rules specifically state. It's like it confuses me, because you're sitting here telling me that when I read these words, that when it says that a defendant has a right to be at all stages of their trial, including arraignment, that it confuses me when you're telling me that what it really means is that I do not have a right to an arraignment. And these are federal rules. These are federal rules of criminal procedure. So it concerns me when you're telling me that the state is constantly denying people's rights to appear in their own trial for the sake of expediting. When the prosecutor came to the judge 6 days before my court date and asked the judge to remove my free speech and rights to be able to gather discovery, I should have been able to object right then and there. So when you say that the defense, that's me, I was ProSe, when you say the defense has no right to speak to the judge until the actual day of the trial, you're just wrong. You were just completely wrong, and it's not disrespect. It's just I'm confused how you have come to the conclusion that people just show up for trial, that they don't get discovery, that they don't get to subpoena people, that they don't get documents, that they don't get to have motions, that they don't get to raise objections. It confuses me how you've presented that to me as such. Alabama constitutional rights. Under Section 25, I have a right to assemble, meaning access to those public lands again. Under Section 25, I have a right to petition. That means filling out those complaint forms that are covered under the Open Records Act of Alabama. Section 25, I have a right to protest. That means coming in hot and bothered, as you stated. I'll remind you again that I called to make a complaint on Sunday to my civil servants. My civil servant, the dispatcher, filed a false police report against me saying that I had threatened civil servants. What that's called is called swatting. When you call the police and you make false claims to them and you send an armed response to someone's house, people die from that. That's a crime, you know? And, again, citizens have the right to protest. They have the right to remonstrance. For that dispatcher to try to swat me is inconceivable. It just blows my mind. Um, Section 25, right to remonstrance. That means telling my civil servants they will not refuse to provide services in according to their oaths sworn. Um, you know, when they started refusing me service, they opened themselves up to a remonstrance. I have that right any time. It's a federally protected right. If I wanted to, I could have told Deputy Lee, fuck you, right there in that building. That's protected free speech. For me to say shit yeah, and you've already said that you agree with that, that's fine. But the point is that the civil servant refused me services, and then I provided them remonstrances, and then they filed another false police report against me. That field report is full of lies that can be proven by the video evidence. This whole thing where I crossed over into unauthorized areas, I would love for them to prove that. I would love to be able to talk to them about me taking their paperwork when what was taken was a sign-in sheet from the sign-in desk that's a public document for the use of citizens to get public services. That is not their document. It was not in their possession behind any non-public area. It's a simple lie. Section 13A7, criminal trespass. If I was never there unlawfully, then I was accused of a crime, and I'm innocent until proven guilty in a court of law. The law says the defendant entered or remained unlawfully in or upon the premises. So, unless I committed a crime, there was no lawful order for me to leave. Yeah? You're telling me that they didn't actually accuse me of a crime, that I was just being disorderly, which is not unlawful. Unless it rises to the level of a crime, which then they can charge me with a crime. Okay? If there was no crime being committed, they violated the law. It's as simple as that. I still know it 100% certainly I have lawful access to my public documents. So, number 2 piece, the defendant did so knowingly, entered unlawfully. No. I'm still 100% certain to this very second that I have legal and lawful access to go into that place, especially while I'm on trial and have access to discovery to go and get documents relevant to my case, just like the documents you have. Those documents were controlled by Jefferson County Sheriff's Office, which I have no legal right under this court order to contact them. How am I supposed to formulate a defense for myself when they are refusing to allow me to have access to witnesses, to documents, and to the scene of the crime per Rules of Criminal Procedure, Rule 16.1? If you got those documents, how in the world did I not get those documents? I requested them. I should have been able to walk into that building and get them by request, like any other citizen. It says a person enters or remains unlawfully in or upon premises when he or she is not licensed, invited, or privileged to do so. I don't believe that the state has even tried to prove that I have no right or privilege to enter the public spaces per the U.S. Constitution's First Amendment, as well as Alabama's Constitution. You know, you wanting to fold on this so quickly, it's not okay. I know I have the right to the U.S. Constitution and my free speech and thus access to my public lands and public servants. And it says in the law, an intruder acts knowing if he or she is aware of the fact that he or she has no license or privilege to enter or remain. Once again, the law, I believe, one of the laws we're covering here says person. That means even non-U.S. citizens, you know. It says that the person authorized with trespass is Deputy Lee in accordance with the law. It says there is a person. I don't believe that it's Deputy Lee who's authorized to trespass people. I don't think it's Deputy Lee who gets to tell people who can and cannot get that criminal complaint form. You'll notice when Mr. Mays executed Deputy Lee's accusation and arrested me under those accusations, that he simply asked the civil servant up front to print out a copy of the complaint form and give it to me, which of course they did not, you know. But why is Deputy Lee not complying with the law and a lawful request for public documents? He told me that I had to give my ID over to him to get documents. And you say that police can lie, that's fine. But he goes on to say that I was argumentative, which is again another lie. He was literally straight out misrepresenting the law. So for a citizen to sit there and say, for him to sit there and say, well, it's a law that you have to give me your shoes, for a citizen to say there's no such law as that, that's not arguing. You know, that's ridiculous. And, you know, that needs to be defended in court. People have a right to discuss matters with their civil servants. The Open Records Act here, item B of Alabama law. The right of citizens to inspect and copy public writings. The complaint form, again, is a public document. They had no right to deny me my constitutional right to get the complaint form. Every citizen has a right to inspect and take a copy of any public writing of this state, except as otherwise expressly provided by statute. And the complaint form, if you can provide me a statute that says that the public does not have lawful access to a complaint form, then once again, if you show me evidences that I'm wrong, then I'm willing to accept them. When you showed me Rule 4.4, again, that's not evidences against Rule 9.4. If 9.4 didn't matter, they'd take it out. They'd strike it. I spent decades in code enforcement, looking up laws across this nation and other nations, and making sure that my projects conforms to the law. They don't just leave laws on the books that it makes no sense at all. Section 13A 11.7, disorderly conduct. If I was accused of this crime, and you say that I wasn't, so once again, if I was not accused of disorderly conduct, there's no lawful reason to have removed me from my First Amendment activities. Okay? Secondly, if they did accuse me of disorderly conduct, big D, big C, and thought that they had a lawful reason to remove me because Deputy Lee decided to find me guilty, regardless of my presumption of innocence, under Rule 2.1, when he started that accusation by document, that's a part of a criminal procedure. And he finished off that criminal procedure by judging for himself my guilt. He decided what my sentence should be, and he passed on that sentence when he has no authority. That's the executive branch. Law enforcement's executive branch. They don't have any authority of the judicial branch to be adjudicating people's innocence or guilt. That's ridiculous. So if he accused me of big D, big C disorderly conduct, then he's violated my rights. If he did not accuse me of big D, big C, then he's violated my rights by removing me from my First Amendment activities. So I either get my First Amendment activities, I either have my rights to First Amendment activities, or I get my right to due process and a fair trial and be able to defend myself against these accusations of being disorderly in public. I imagine they're going to want to put this disorderly conduct complaint form into evidence. And yet, I'm left with no way to get witnesses to confront them about these accusations due to the court and the prosecution removing my right to discovery and accessing my civil servants, to even know their name, to be able to seek to subpoena them. My right to the documents that I have had to have you retrieve for me, I'm sorry, I skipped ahead. Alabama Rules of Criminal Procedures, Rule 16.1, discovery by the defendant. You can see my previous motions. Upon written request of the defendant, the prosecutor shall, within 14 days after the request has been filed in court as required by Rule 16.4c. Number two, the discovery thing, that's probably about knowing the charges against me, getting the documents. My right to the documents that I had to have you retrieve for me. Number one, permit the defendant, and this is what the law says, permit the defendant to inspect and copy any written or recorded statements made by the defendant to any law enforcement officer, official, or employee which are within the possession, custody, or control of the state, municipality, the existence of which is known to the prosecutor. And it might be the wrong one that I was wanting to look at, because it also says that about another part. However, I have a right to inspect and copy any written and recorded statements. I asked for those documents not until you came along. On the very day of my trial did I get access to those. Actually, no, it was after that. Yeah, you had to email them to me. Yeah, I had to ask them. I had to ask for you to give them to me. Yeah, because the state simply refused. 3. My rights to access public lands was preempted by Deputy Lee, the county DA, and the sitting judge by unlawful trespass, unlawful court order, restricting my free speech. It says that the rules of discovery, it says permit the defendant to analyze, inspect, and copy or photograph books, papers, documents, photographs, tangible objects, controlled substances, buildings, or places, or portions of any of these things which are within the possession, custody, or control of the state municipality. That means Jefferson County Sheriff's Office, which I had a preemptive deprivation of my rights to access those public lands. I'm not sure how it could get any clearer. I have a right to discovery. They took my rights to be able to access my own government preemptively to keep me from being able to formulate a defense in my trial. And if you say no, then tell me, why did they refuse to tell me the charges? Why did they refuse to let me have access to the buildings, the papers? Rule 43B4, delivery of charges to the defendant. You can see my previous motion asked the charges to be delivered, which they just ignored my rights under that one too. Rule 9.1, the defendant to be present at every stage of the trial. I have been denied the right of attending my arraignment. This is when the prosecution asked the judge to deny my free speech. This is when the prosecution asked the judge to deny my right to public documents. And this is when the prosecution asked the judge to deny my right to a fair trial. This was 6 calendar days before my court date and denied me the right to speak, to object to my removal of U.S. constitutional rights. The state of Alabama may find it expedient to not have the defense at trial, but that means nothing to my federal rights to be present. Even if Alabama, you say it's done away with rules of criminal procedure 9.4 to make it expedited, I still have federal protections. You know, you can't just be like, oh, well, we're not doing 2/3 of the trial. You'll show up for trial and you get no discovery, you get no documents, you get no access to subpoena people. I have federal protections. Two, pretrial appearance. The judge stated this is when my motions would be heard. The judge skipped the pretrial hearing. Now I had issues to discuss. There are several motions that have just gone unanswered. I specifically asked the judge for a more definitive statement on why they were removing my free speech to my government. They just ignore it. Why? Because I think it's very well known that it's improper, it's unethical, it's unlawful. What exactly are my charges stemming from? You stated the trespass was not an accusation of a crime under Rule 2.2. A person cannot be trespassed unless they are unlawfully. If the trespass was not an accusation of a crass or disorderly conduct, not an accusation of a crime, I was there lawfully. If I was accused of a crime of disorderly conduct, I never had a fair trial, due process, and the law enforcement officer decided to judge and sentence a person for a crime they themselves accused them of. It cannot be both. I mean, you understand that, right? It can't be both that. It can't be both that I did not commit a crime and therefore they lawfully trespassed me. It can't be that, because not committing crime isn't a lawful reason to kick people out of their own government. If you're not being unlawful, there is no basis for removing a person. If they thought that I was being unlawful, they've denied me a fair trial to defend myself against their accusation of me being unlawful. That's a federal right to face my accusers, to have a fair trial, to have due process. It can't not be both. It cannot be both if they've decided that they didn't charge me with a crime, but they removed me lawfully. It can't be that they're charging me with a crime of disorderly conduct as a basis to kick me out, but I don't get to defend myself against my accusers. You've got to understand that. You've got to understand that it can't be both. They can't kick you out for being lawful and then deny you a right to do anything about your unlawful removal of your free speech under the color of law. That is deprivation of rights under the color of law. They told me a lie saying that I was there unlawfully. They used a law to deprive me of my First Amendment rights that I was currently engaged in lawfully. This no contact order. This no contact order prohibits a person from being in physical or verbal contact with another person, which is a face-to-face or over the phone or internet. This type of order is filed when an action has already taken place. This no contact order between me and the entire state of Alabama, what is the lawful basis of that? This is what upset my first lawyer. What is the basis for removing a person from their government? Right now, I have a no contact order with Jefferson County Sheriff's Office. I and my elderly mother live in unincorporated county sections under the police authority of Jefferson County Sheriff's Department. Right now, this court order is saying that I have no police protection, that I have no legal right to call and ask for help. I have no legal right to report a crime. I have no legal right to petition my government. It is no legal right for me to see one of my civil servants commit a crime and to report that crime. Right now, when I was under duress in the jail cell and they made me re-sign papers under threats of throwing me in jail for, they couldn't explain it to me. I'm not able to make a complaint of that because I have been deprived my rights to petition my government under color of law by Deputy Lee. According to the Freedom of Information Act, the county DA says that there are no people trespass from public lands. And I'd imagine because it's just not legal, it's just not lawful. You tell me that when we spoke, you're like, oh yeah, they do that all the time because people get fixated on a place. Being fixated on a place isn't illegal. And it's frustrating me. You say you've taken constitutional law. Under what constitutional directive is there to remove people's right to public access without there being a crime? You know? It doesn't matter if people annoy the civil servants. We have the right to annoy our government. It's specifically in the Alabama Constitution. It frustrates me that this is the way my state is treating citizens. And that there's no process to try to have these unlawful trespasses reviewed because there's just no record of them. It's off the books policing, denying people their rights under the color of law. I am beside myself that the courts decided that my family doesn't deserve the protection of the Sheriff's Department that collect revenue and funding from census data because we are under their authority. They get money to help protect the community that we live in. A no contact order means that I can't be in physical contact with Jefferson Sheriff's Department. How does that work out? Say I need to, say someone hit me in a car in Jefferson County, and I need to go get a police report for my insurance. I've now lost the right to even have insurance on my car because Deputy Lee thinks that I don't have a right to access my own government, and because the judge and prosecution thinks that I shouldn't have rights of every other American citizen. And you're like, oh, well, that's just ridiculous. No, it's not. No. I want to go and get my arrest record right now for this trial. I've already called the county DA. Under Open Records Act, the county DA has already confirmed that I have access, legal access, to my arrest record. So, no, it's not a ridiculous situation. It's a current situation, and it's a violation of my federal rights. A violation of my rights to discovery, to a fair trial. Sixth Amendment. You spoke of strategies for my defense. And you know you don't have to pick one strategy, right? I mean, if a police officer steals your money and breaks your arm, you don't have to pick, do I go after him for stealing money or do I go after him for breaking my arm? You go after him for whatever they did wrong. Yeah? If they did 10 things wrong, you don't pick one thing. You go after all 10 things. You think the state's going after one thing I did wrong, or are they just making up shit and just throwing everything at the wall and see what sticks? Here's my strategy. Question actual witnesses in my case. The two civil servants and Deputy Lee, subpoena them. If this is time restricted, move to number 2. If we can't subpoena them because there's not enough time, because I've been denied my rights to discovery, you know, that's just another mistrial issue. Number 2, challenge the trespass lawfulness based on no unlawful actions to have a person removed from First Amendment activities. Number 3, challenge the lawfulness of the trespass based on deprivation of rights under the color of law. Number 4, challenge the no trespass by way of personal invitation by Deputy Lee who gave the unlawful order. If the field report is not an accusation of a crime, then attack the reality that no crime means there was never a lawful order to leave a public space. Deprivation of First Amendment rights under the color of law. Deputy Lee used entrapment. You heard me call and ask permission to come down, and not till I got permission did I come down to speak to him about trying to review this unlawful trespass. This law right here says entrapment occurs when an officer under his or her control incites, induces, allures, or instigates a person into committing a criminal offense which that person would not have otherwise committed and had no intention of committing. The defense of entrapment is not applicable where the officer merely affords an opportunity to one intending to violate the law, and which I most certainly wouldn't. That's why I called and got permission to come down and have a invitation to the property, even though I fully believed that I did not need his invitation, as he has no right to block me from my federal rights. Yet still, I tried to do the correct thing. It's definitely a defense, and it's definitely what did happen. I think it's hard to say anything else when he told me, come on down, and then when I came on down, he arrested me. Had he not given me permission, I wouldn't have come on down, or I would have come on down without talking to him about it first. So I think that's a very important distinction and very relevant. If the field report is an accusation of a crime, attack due process has to be a Rule 2.1, deprivation of due process, fair trial, deprivation of right to trial under color of law. I want to win this case. I'd rather not have a mistrial or dismissal, but if not, then a dismissal is preferred. If not, a mistrial based on deprivation of rights to appear per Rule 9.4 in the Sixth Amendment to the U.S. Constitution, deprivation of right to collect discovery and question witnesses, visit the scene of allegations per Rule 16, deprivation of the right to discovery based on no contact order against my First Amendment rights. I need to look through my other motions, you know. Let's look at my emails here, what I sent you, because, you know, when I told you about my plans to use you as advisory counsel, it was a no-no for you to go and tell the judge. I have client lawyer relationships. Whatever I say to you is confidential. You know that, right? So if I have a legal strategy, it's not okay for you to go and tell the state. The state is not a part of my defense team. Yeah? If the state was part of my defense team, they would have allowed me to have discovery. They would have given me those documents. They would have respected my right to appear before them, and they would have answered my motions when presented. You know? Rule 6.1, right to counsel. Waiver of the right to counsel. A defendant may waive his or her right to counsel in writing or on the record, which means in court at any point in time. After the court has ascertained that the defendant knowingly, intelligently, and voluntarily decides to forego that right, at the time of accepting the defendant's waiver to the right to the counsel, the court shall inform the defendant the waiver may be withdrawn and counsel appointed or retained at any stage of the proceedings. That means, once again, I care about what the law says. That means, and you know, I'm going to have to use you, and I'm sorry to put this in this manner, but I'm going to have to use you and your skills where I see applicable, and go pro se where I feel it's necessary. Your strategy was to sign away my rights when I've done nothing wrong. I can't tell you how many people have died, bled, given up their family to make sure that we have rights, you know. The suggestion for me to sell them to the state in exchange for up to a $300 fine doesn't set with me well. If you don't want to confront the judge about these unlawful activities that the judge has committed, then I will. I've got no problem speaking truth. None at all. You shouldn't either. I mean, if it's the reality, then that's the reality. The judge shouldn't have done these things. If the judge doesn't want to have people complain, or she doesn't want to have people complain about unlawful activities, don't do unlawful activities. That's the way to have the judge not be confronted by people about unlawful activities. Federal rules over here. Rule 43, defendants present. Misdemeanor offense is punishable by fine or imprisonment in not more than 1 year or both, and with the defendant's written consent. That's when my defendants can be absent per federal rules. So even if the state of Alabama thinks it's easier and more expedient to not allow people to be present at their own trial, the state doesn't overrule federal protections of American citizens. I'm an Alabama resident. What I am is an American citizen. I just happen to reside right now in Alabama. I've resided other places. I've never stopped being an American citizen. My protections are from the Constitution, not the state. The state laws are derivative from the federal laws. Amendment 6 here, notice of accusation. Once again, I think this goes back to my Sixth Amendment right to be informed of the accusations against me. I'm going to be looking at trying to get some judicial review. I'm going to be filing some civil rights complaints. I'm going to be looking at malicious prosecution for the deprivation of my rights to appear, my deprivation of my rights to discovery, and First Amendment protections as well when the prosecution went ahead with this case and decided that I didn't deserve to have rights under Alabama Constitution, Alabama law, rules of criminal procedure, U.S. Constitution, U.S. federal rules of prosecution, so. And I think that covers it. I'm intense. I'm not upset with you. I don't really know your experience, but you said you were going to talk to more seasoned people, so I guess you're still learning and stuff, or not learning, but gaining functional experience in the courtrooms. So I don't want you to take offense. I'm not upset with you. Let's have a difference of opinion with you. You said you wanted to lead strategy, but that's just not how the Bar Association works. I have goals, and you're going to help me meet those goals. You don't have goals, and I'm not here to help you meet those goals. Okay? Man, like I told you, I've done just a little background, because I really do like you. I like you. I like your energy. I like where you're coming from a lot of things, but I just think that you're wrong on a number of things. I mean, that's okay. Hell, I'm not right all the time. Just happens to be. I've researched this for a number of years. I've looked into these things for a number of years, and I am rather certain that you just can't remove people's federal rights from them because you're upset that they want to come and file a complaint about your church services that you're using taxpayer funds to deliver to the masses, talking about evil spirits and ghosts flying over Birmingham. And it's just, the whole situation is ridiculous. Like I said, I'm an activist. I'm a protester. I came to do this for a good reason. You probably saw the complaint and maybe even seen some of the Facebook posts where they upset one of the citizens with their fantastical talk of Ghostbuster ass shit over Birmingham. I mean, that's what it reminds me of. What the preaching was talking about was Ghostbuster scene when it explodes and there's evil ghosts flying all over the city. Who are you gonna call? Jefferson County Church. And when there's evil spirits flying over your city, and it's just so out there. It's insane. So I've done a lot of research on people's rights. I care about these things. I debate them a lot. Doesn't mean that I'm perfectly right and honest. And to be honest, we already talked about Dunning-Kruger. I very fully admitted that I don't have experience on the functional side of law. I have a ton of experience on the letter of the law, intent of the law, but not so much on the mechanics. Man, lawyers. No offense. Man, 5 years I fought for my children. 5 years. I hired lawyers, and the first couple of years I paid them good money to make sure that I had an ability to co-parent my children. I found out about a year and a half into the process that 2 years previous, Alabama had passed a law guaranteeing that right. So, while I was sitting there fighting for a right that I already had, my children were being denied health care, being denied an education, being denied all kinds of things. So I got rid of them. Then the next lawyer, said he was a father, said he had gone through the same thing as me. said he'd be there to help protect my children. Then he sent an off-duty police officer who slept through the trial. So got rid of them. They told my family and children they were afraid I was going to get them disbarred. My children had 3 guardian ad litems. I ate all 3 of their asses the fuck alive. Why did they have 3? Because I ate them the fuck alive and got them kicked off the fucking case for not doing their fucking job and not following the fucking law. I did this for 3 years, and like I said, I have faced all kinds of accusations. I've faced all kinds of squads of civil servants in my quest to do my children correctly and make sure that they had their rights respected. I told you I sent my daughter off to be a constitutional lawyer. You know, I mean, it sure is unfortunate, but you know, I don't even have contact with my children anymore. You know, not talking badly about my ex, but once again, the realities are the realities. You know, she had mental illness, and she, like I said, I faced all kinds of accusations, and when children have the trust of their parent, it's a little heavier weighted. You know, so you know. The reality is that I'm willing to fight what's just, you know, for the long term, and regardless of other people's feelings. Made me a bad person, I don't know, but you know, my children deserved an education. They deserved the mental health care that the court ordered and stuff. So when it comes to people's rights and making sure they're treated correctly, I'm very passionate about it. That's the majority of my legal work. I did represent myself against Birmingham Police Department, but they dismissed the case. I did represent myself against traffic, collected evidence and some stuff, and I did good on that one. So you know, this isn't you know, some far off ideals for me. So when I tell you that I have these rights, I want you to know that I'm fairly damn certain, to the point that I'm willing to bet my life that I still withhold my First Amendment rights, and I still withhold my Sixth Amendment rights. You know, inalienable rights does mean just that. Like I said, man, I hope I don't upset you, but the reality is, right now my goal is to do some good. Like I said, I tried to come and do a good deed, and you know, try to make sure that the separation of church and state was adhered to. You might see on my videos First Amendment audit. You know, I'm not one of those First Amendment auditors. First Amendment is free speech, but also other parts. Establishment Clause, separation of church and state. So when you see First Amendment audit on my video, it's about the separation of church and state. I love doing a good deed. I love finding problems and fixing them, like I said. And right now, there certainly is a problem right now with the civil servants feeling like they have the legal ability to deny whoever they want services. And if the people don't like it, well, they'll just trespass them and remove their rights from them. That's troubling. Like I said, it's troubling also that you tell me that it's commonplace for the court to deny people a chance to speak at their own trial to expedite things. I completely believe you, because when I had a date and they did something 6 days prior without notifying me, yeah, I mean, it was very expedient for the prosecution to be able to strip me of my rights and me not be able to be there to defend myself, to object to the stripping of my rights under the color of law. I'm sorry about your offer to them. I tried to speak to them. I even did the rules of criminal procedure to set up an evidentiary swap between me and the prosecution, but they ignored that too. They've had their opportunities. Fuck them. Yeah. I tried to give them opportunities. I tried to speak to the judge about taking away my free speech, and yet the judge still persisted. Fuck them. Fuck the judge. Fuck the civil servants. Fuck the cops over there. They can all kiss my ass. I have rights. My rights are worth defending. I hope to have your help. I hope to have your guidance, because I need it. Just, I will handle strategy. You can help me handle the mechanics. I told you I tried to find some other lawyers to do this, but they straight up told me that they had other clients and they had to worry about the working relationship between the prosecution and the judge that they had, as well as other civil servants. So I told them I understand their sensitive position. I understand if you're in a sensitive position. If you don't want to tell the judge to kiss your ass, I'm more than happy to tell the judge to kiss my ass. Yeah. I think I already have in several of my motions, so I really don't mind continuing to tell them to kiss my ass. You know. I'm gonna end it there, though. Man, you know, actually, I'm not. I'm gonna do something. I hope that you enjoy. I hope you have a great week. I hope I didn't upset you. I'm intense. I know that. Man, you know, one of my children's guardian ad litem, that poor guy. You know, first time I met this guy, man, I just came in. I'm like, hi, nice to meet you. I guess he had heard about my interactions with the police departments and the other officials regarding my children. Boy, that dude, he you know, supposedly he didn't even have any anxiety issues, but that dude seriously just like broke down right then and there. I'm like, so you know, you know, boy, trust me, man. I completely understand that I am a very vibrant person. Yeah. But none of that removes my rights under the law, you know. So, I like to tell people this. I think it's funny. I'm jovial, goddammit. You know, I really do enjoy a smile, enjoy a laugh, you know. But, you know, I also enjoy being serious, taking care of business, and making sure that things are running correctly. So, I want to say that I really do appreciate you. I appreciate your time, your services. I really do appreciate your public service to those people unfortunate that don't have the ability to protect themselves.